Good morning, ladies and gentlemen, especially to my students in Philippine Constitution. We have already concluded the part one or module one of the subject Philippine Constitution. So comes now part two or module two of the subject. You had already, we had already your recitations and all of your recitations, whether it was done online or the personal call, were properly recorded. In the part two of the discussion of Philippine Constitution, we will be discussing the Philippine citizenship, Article 4, suffrage, Article 5, and the introduction of the three great branches of the government consisted of Articles 6, 7, and 8. We have bypassed or did not discuss for the meantime the Bill of Rights because we will be setting aside part 7 and 8 for that purpose, no, of all the 22 articles of the Bill of Rights. We will be dividing them into two modules. So I repeat, they may be part 7 and part 8. So to proceed with the discussion of citizenship, the citizenship is defined as membership in a political community and carries with it rights to political participation. So, of course, a person that is a member, or who is a member of that citizenship, is known as citizen. Who are now the citizens of the Philippines? Article 4, Section 1 of the Philippine Constitution enumerates the citizens of the Philippines. So who are they? Yon. First, those who are the citizens of the Philippines at the time of the adoption of the 1987 Constitution. Second, those whose fathers or mothers are citizens of the Philippines. We will be discussing the case of Fernando Po Jr. in this case. And third, those born before January 17, 1973 of Filipino mothers who elect Philippine citizenship upon reaching the age of majority. We will be discussing a specific case for this matter. And those who are naturalized in accordance with law. Before discussing citizenship, however, let me stress a very important case in relation to citizenship, because this is a situation that is commonly being overlooked, especially by rich persons. So the title of the case is People of the Philippines versus LABO. What happened in this case? There was a person by the name of LABO, and these are the facts about him before running as mayor of Baguio City. So first, he is a citizen of the city of Baguio. So with respect to citizenship, with respect to the residency, there is no problem in relation to it. Next is he is a popular personality, one of the popular personalities of Baguio City during that time, because he is a businessman. And next is his wife is an Australian citizen. And the last fact about him is, in some of the documents that he had accomplished prior to his becoming a politician, he indicated therein that he is an Australian citizen. So I repeat, in some of the documents that he had accomplished prior to his becoming a politician, he indicated therein that he is an Australian citizen. Afterwards, he ran as a mayor of Baguio City, and to tell you, he won. The issue here is he qualified to become the mayor of Baguio City? As much as the citizenship is concerned, to tell you, according to the Supreme Court, no. He is not qualified to become the mayor of Baguio City. According further to the Supreme Court, Philippine citizenship is not a cheap commodity to be renounced if wanted to. In Tagalog, ang citizenship natin, hindi ito yung simpleng bagay lang na baliwalain mo kung ayaw mo, tapos i-claim mo kung gusto mo. No? In fact, this citizenship is also one of the issues that was used against the Lopez family in relation to the renewal of the franchise of ABS-CBN. Okay, let's go now to the discussion of the citizenship proper. There are three ways how to acquire Philippine citizenship. So that is by means of birth, by means of naturalization, by means of marriage. So by means of birth, there are two rules or rights or laws under it. We have the law of the soil or the jus soli, and we have the law of the blood or the jus sanguinis. So under the jus soli, law of the soil or right of soil, it is a policy by which a person acquires citizenship of a state by being born in the territory of that state. Kaya kung naipanganak ang isang bata sa territory ng estado na yon, then he is already a citizen of that state. Some states of the United States are adhering in this right of soil. The jus sanguinis, on the other hand, is also known as the law of the blood or the right of blood. So the Philippines adhered in the law of the blood or the right of blood, wherein it is a policy by which the citizenship is not determined by the place of birth, but it is being determined by the citizenship of the parents. So in the Philippines, it is expressly stated under the Constitution that if the parents of the child is a Filipino citizen, we are talking about the mother or father, then automatic the child is also a Filipino citizen. So because of the combination or because of the interaction of this jus soli and jus sanguinis, dyan na lumalabas yung tinatawag natin na dual citizenship. Okay? So, how does the dual citizenship upon birth come into play? Imagine that there is a Filipino spouses who will be going to the United States, settling there, then bearing children there. So inulit ko, may mag-asawa na Pilipino, pumunta sila sa United States, nagkaroon sila ng anak doon, of course, lumabas doon sa United States. Like what happened in the case of Lopez. So, that child will be acquiring dual citizenship by applying this jus soli and jus sanguinis. So, why? Because according to the US government, that child is a US citizen because naipanganak siya sa territory ng US. According also to the law of the Philippines, that child is a Filipino citizen because their parents are Filipino citizen. No? So, I repeat, upon birth, that child acquires dual citizenship. What if we will be going to the reverse? Okay? I-reverse natin ang sitwasyon. Mag-asawang US citizens, they will be coming here in the Philippines and having a child here. The question is, what will be the citizenship of the child? No? So, if we are going to analyze it, initially, that child is a stateless person. No? Initially, that child is a stateless person. That is because that child cannot be considered as a citizen of the Philippines because the parents are not Filipinos. That cannot also be considered as a U.S. citizen because it was not born in the U.S. soil. So initially, that child is a stateless person. What is the remedy of the stateless person? We will be discussing it later on. No? And next way, how a person acquire Philippine citizenship is by means of naturalization. Naturalization is the legal act of adopting an alien and giving him with the privilege of the native-born citizen. So if there are some aliens or some foreigners who will be coming here in the Philippines and they will be undergoing the naturalization process, then that alien or that foreigner will be may be considered as a Filipino citizen already. And next way, how a citizenship may be acquired is by means of marriage. If I'm not mistaken, the provision of the 1935 Constitution goes this way. If there is a Filipino woman who will be marrying a foreigner, then maalis sa kanya ang kanyang pagka-Filipino citizenship, and the citizenship already of that Filipino woman will be the citizenship of her foreigner husband. Okay? So that is an act of acquiring citizenship by means of marriage. Kaya kung babae ka, paano kung ang batas natin ay, kung ang babae, nagpakasal lang foreigner, sa batas natin, hindi na Filipino citizen yun, at ang kanyang citizenship ay kung ano ang citizenship ng kanyang foreigner na asawa. No? So, those are the ways how Philippine citizenship is being acquired. So, let's go to the case of D. CUENCO versus Secretary of Justice. This involves the third citizen of the Philippines, or the third paragraph of the citizen of the Philippines, wherein in relation to the act of electing Philippine citizenship upon reaching the age of majority. So what happened in this case? There was a person. By the way, this case happened way back 1920s. So this is an old case. No? There was a person by the name of Alfonso D. CUENCO. Ang kanyang father is a Chinese at ang kanyang mother ay Filipino. Our law during that time was, if a mother will be marrying if the wife is a Filipino at ang kanyang husband ay foreigner, the citizenship of the wife na Filipino will be removed. Okay, matatanggal sa kanyang pagka-Filipino at ang kanyang citizenship ay kung ano ang citizenship ng kanyang husband. Okay, that was our law before. How about the citizenship of the child like Alfonso D. Cuenco in this case? No? So, buti pa si mother. Okay? Naging Chinese na siya. How about the citizenship of the child? So, our law during that time was when that child will be reaching the age of majority. I don't know if it is 21 or 18 during the time. When he will be reaching the age of majority, he will be formally electing Philippine citizenship. No? Manunumpa siya na Filipino citizen within 3 years after reaching the age of majority. So, ang ginawa ni Alfonso D. Cuenco, ay wala pala siyang ginawa. Okay? Wala siyang ginawa in order to elect the Philippine citizenship upon reaching the age of majority. He was already 28 years old during the time and he had already some children. No? But hindi pa siya nanunumpa o he did not yet elect Philippine citizenship as his formal citizenship. But previous to the formal election, sa mga dokumento na finifill upan niya, linalagay niya na siya ay Filipino citizen. So, after several years, question ang kanyang citizenship. Sabi nila, hindi daw siya Philippine citizenship kasi hindi niya inelect ang kanyang Philippine citizenship within 3 years from the age of majority. So, tama ba yun? According to the Supreme Court, no. The 3-year period na kung saan siya ay manunumpa bilang Filipino citizen or electing Philippine citizenship may be extended. That is because he already considered himself as a Filipino before the formal election. No? So that is the case of the CUENCO. Let's go to naturalization. As I told you a while back, foreigners may be coming here in the Philippines and they will be undergoing the naturalization process and yun na, they are already citizens of the Philippines. There are 2 ways how to acquire citizenship by means of naturalization. And they are the direct mode and the derivative mode. So, in direct mode, let me summarize it this way. Kasi matagal na usapan to kung sakaling i-discuss natin yung proceedings under the direct mode and those under the derivative mode. So, sa direct mode ng naturalization, there is an active participation of a person for him to become, to be naturalized citizen of the Philippines. Katulad ng judicial proceedings, administrative proceedings, special act of Congress, etc. But in derivative mode, there is no direct participation of a person. No? Sabit lang siya. So, the direct mode of naturalization includes minors na kung saan ang kanilang parents ay na-naturalized na Filipino citizen, kaya sila ay Filipino citizen din by means of derivative mode. No? So that is the distinction between the modes of naturalization. There are 2 classifications of citizens. We have the naturalized citizens and we have the natural-born citizens. So, the natural-born citizens are those who are citizens of the Philippines from birth without having to perform an act to acquire or perfect Philippine citizenship. So pag panganak pa lang, Filipino citizen na. No? So the other natural-born citizens are those born before January 17, 1973 of Filipino mothers who elect Philippine citizenship upon reaching the age of majority, which includes the CUENCO, okay, that we have discussed a while back. So, inulit ko there are two classifications of citizens. We have the naturalized citizen. Formerly, they are foreigners. They came here in the Philippines and undergone the naturalization process with an exemption, of course, with the derivative mode. No? Afterwards, they acquired the Philippine citizenship. The other citizen of the Philippines are those natural-born citizens wherein wala silang ginawa, automatic. They are citizens of the Philippines, except again with respect to citizenship in that are acquired by means of derivative mode. So, are there some substantial distinctions between a naturalized citizen and natural-born citizens? To tell you, there is no substantial distinction. It only happened that there are some positions in the government that are reserved only to natural-born citizens. But let's go to a little bit complicated story. BENGZON versus CRUZ. This case must be learned by every Tarlakenyo because the one involved in this case is from San Clemente, Tarlac. So, Theodore CRUZ, pangalan ko pa naman, ano? Theodore CRUZ is from, he was born at San Clemente, Tarlac. Of course, his parents are Filipino citizens. So, when he became adult, that was more or less in 1985, he went to the United States and he was enlisted as a member of the armed forces of the United States. Ito ang batas natin. Okay? Kung sakaling naging member ng armed forces ng ibang bansang ang isang Pilipino, automatic, the Philippine citizenship will be removed from him, no? Will be divested from him, at maging citizen na siya ng bansa kung saan siya ay member ng armed forces. So this was what happened in the case of CRUZ. So he is a natural-born citizen. He went to the United States, naging US citizen kasi member siya ng armed forces ng United States. What happened there was, nung nag-retire siya na member ng armed forces ng United States, he went back here at Tarlac. Tapos tumakbo siyang congressman. One of the requirements ang naging issue kay CRUZ ay, ang isang requirement kasi for a person to run as congressman is he must be a natural-born citizen. Okay? Kailangan na natural-born citizen siya. Ang ginamit laban sa kanya, hindi na siya natural-born citizen kasi pumunta siya sa US, naging member ng armed forces at naging citizen ng US. Okay? So, pwede ba siyang tumakbo? Okay? to cut the story short is, pwede ba siyang tumakbong congressman ng Tarlac? To tell you, yes. No? Pwede siyang tumakbo. So, if a natural-born citizen loses his citizenship by renunciation or other mode, he is still considered as a natural-born citizen if he will subsequently reacquires Philippine citizenship. No? In Tagalog, kung ang isang natural-born citizen pumunta sa ibang bansa, naging citizen ng ibang bansa, afterwards, bumalik siya at binalikan niya ang kanyang dating citizenship, ang kanyang binalikan ay natural-born citizen, hindi naturalized citizen. So, as I told you a while back, there are some positions in the government that are exclusively intended for natural-born citizens only, like the President of the Republic of the Philippines, Vice President, Senators, members of the House of Representatives, Justices of the Supreme Court, Chairman and members of the Constitutional Commissions, and the Chairman and Constitutional Commissions, because the Constitutional Commissions is consisted of the Civil Service, the Commission on Elections, and the Commission on Audit. You may ask, may a naturalized citizen apply as a policeman here in the Philippines? To tell you yes, in my personal opinion, that is because under Republic Act 8551, ang nakalagay naman doon ay citizen of the Philippines. Hindi siya nakalagay na natural-born citizen of the Philippines. To tell you, as I repeat, there are two citizens of the Philippines. We have the natural-born and we have the naturalized. So, the Constitution and some of our laws only provided some positions that are exclusively to be handled by natural-born citizens. Let's go to the case of TECSON versus COMELEC. Ito yung sinasabi ko sa inyo kanina. In the case of Fernando po. So, what happened in this case? We all know that way back 2004, si Fernando po ay tumakbong president ng Pilipinas, no? Kasama sina Eli Pamatong. Kaya nagkaroon tayo ng Eli Pamatong versus COMELEC. Si Fernando po naman, nagkaroon tayo ng TECSON versus COMELEC. So, to tell you, I'm not so much naman in the personal circumstances of Fernando po Jr., but pasensya na because it must be explained for us to understand the case. No? Fernando po Jr., the real name, ang kanyang totoong pangalan ay Ronald Alan Kelly po. Ang Fernando po Jr. ay screen name lang. No? Because ang kanyang father ay si Fernando po, so he claimed that he is a junior. But I repeat, that is only a screen name. Ang kanyang totoong pangalan ay Ronald Alan Kelly po. Ang kanyang father ay Filipino. At ang kanyang mother, si Miss Kelly, ay isang US citizen. To tell you, si Fernando po Jr. ay isang illegitimate child. So, under the law, we all know that under the law, the one that has the parental authority over the illegitimate child is the mother. Yung provision ng batas na yan ang ginamit kay Fernando po. Sabi nila, Fernando po, ang mother mo American citizen at siya ang may parental authority sa'yo. So, it follows, ang citizenship ng inyong mother na US citizen, yan ang napunta sa'yo. Okay? Yan ang applicable sa'yo. So, tama ba yung nag-question ng citizenship ni Fernando po? According to the Supreme Court, no. So, ito ang decision ng Supreme Court. If the law states that the mother has parental authority over her illegitimate child, it means that it is his mother who must take custody and support of her child. The parental authority over an illegitimate child is not intended to help the child not to prejudice, okay? Not to cause prejudice against the child. Medyo may mali sa presentation, no? I'm very sorry about that. So, when we say parental authority of the mother sa kanyang illegitimate child, ang ibig sabihin niyan ay ang support ng mother at ang authority ng mother over the illegitimate child. Yan ang tinutukoy doon. But in no case na i-discriminate natin ang bata na yan dahil siya ay illegitimate. So still, Fernando po Jr. is a natural-born citizen, kaya pinayagan siyang tumakbo noong 2004 election. Unluckily, in the case of Eli Pamatong, na hindi siya pinayagan. Di ba? So, that is in the case of TECSON versus COMELEC. Let's go to the case of VALLES versus COMELEC. Itong kaso naman ni VALLES versus COMELEC is in relation to dual citizenship. Katulad ng na-discuss natin in relation to the Lopez to the Lopez person, okay, a while back. Si VALLES, ang kanyang parents, Filipinos. But he was born at Australia. So, as I told you in the discussion of jus soli and jus sanguinis, a child may acquire dual citizenship, no? So, ganyan ang nangyari kay Miss Lopez, no? So, siya ay naipanganak sa Australia. Ang Australia ay nag-adhere sa law of the soil or the jus soli. Tapos tayo naman dito sa Pilipinas, we adhered in the law of the blood or the right of blood, which is a jus sanguinis. So, to cut the story short, may isang tao by the name of Lopez, yun nga, nagkaroon siya ng dual citizenship. So, renounce niya o binaliwala na niya ang kanyang citizenship dyan sa Australia. Tapos, bumalik dito sa Pilipinas at tumakbong governor. Okay? Tumakbo siyang governor ng, if I'm not mistaken, that is Davao. So, there is already a disqualification case against that person. Paano nagkaroon ng disqualification case? Kasi yung Republic Act 7160, nakalagay doon na bawal tumakbo ang mga dual citizenship. Okay, so naka-enumerate doon ang disqualifications of a person na tumakbo sa position. At ang isang disqualification doon ay dual citizenship. Bawal daw tumakbo yung may dual citizenship. Kaya sabi nila, dahil dual citizen si Miss Lopez, Australian siya at the same time Filipino, hindi na siya pwedeng tumakbo. So, to tell you, according to the Supreme Court, the phrase dual citizenship in Republic Act 7160 must be understood to refer to dual allegiance. Kaya kung dual citizenship, pwedeng tumakbo bilang politician dito sa Pilipinas. ang pinagbabawal ang dual allegiance. Ang pinagbabawal ay yung dalawa ang kaniyang loyalty. No? So, I repeat, dual citizenship is not a disqualification to run for office. The disqualification is dual allegiance. Do not forget that. Okay? What is the title of the case? VALLES versus COMELEC. So, how may citizenship may be lost? Or, uy, may mali sa PowerPoint presentation. I'm very sorry about the PowerPoint presentation, my redundancy. Ano? Dapat ang nakalagay doon ay how may Philippine citizenship may be lost. No? Naulit yung may lose tapos may be lost. Okay, so how may Philippine citizenship may be lost? So I repeat, I'm very sorry about the PowerPoint presentation. So there are several ways how it may be lost. So first is by means of naturalization in foreign country, katulad ng discussion natin kay CRUZ kanina, di ba? Na naipanganak siya dito sa Tarlac, tapos pumunta siya sa US, and he was naturalized there because he became a member of the armed forces of the United States of US, or by express renunciation of citizenship, so on and so forth. Okay, let's go to next. How may citizenship be reacquired after losing it? Okay, so you lost your Philippine citizenship because perhaps you were naturalized in the other country. Afterwards, babalik ka dito sa Pilipinas. How may it be reacquired? Okay, so it is by means of naturalization again, and by means of repatriation. Repatriation ang applicable kay CRUZ, okay, sa kaso kanina. Di ba? Si CRUZ ay natural born citizen, tapos pumunta siya sa US, naging US citizen dahil member siya ng US Armed Forces. Afterwards, binalikan niya ang kanyang natural born citizen. Ang tawag natin dyan ay repatriation. No? So, we have Republic Act 9225. So, Republic Act 9225 is also known as the Citizenship Retention and Reacquisition of 2003. Ang main essence lang naman ng 9225 na ito is if a natural-born citizen will be naturalized to other countries, still they will be retaining their Philippine citizenship. Okay? So, in other words, they will be acquiring dual citizenship. Dual citizenship because they will be retaining Philippine citizenship. Afterwards, they will be accepting the citizenship of that foreign country. So, one of the classic example of this is my mother. Okay, because my mother is a nurse abroad at the United Kingdom. So, she is a natural-born citizen. If I'm not mistaken, that was 2008 or 2007 when she applied and eventually given the UK citizenship. So under this law, she acquired dual citizenship. Still, she is a Filipino citizen by virtue of Republic Act 9225. And dahil nanumpa siya sa UK, she is also a UK citizen. Kaya na nga joke ko siya. That was, if I'm not mistaken, 2010 or 2011. Sabi ko sa kanya, 3 na ang citizenship mo. Kasi you are a Filipino citizen under Republic Act 9225. You are naturalized at UK, so you are a UK citizen. Tapos nag-celebrate ka ng iyong 60th birthday, so you are a senior citizen. So as a whole, you acquired 3 citizenship. No? Let's go to, we have already discussed the LABO case a while back. No? I discussed the LABO case a while back so that we will be having a general overview in relation to citizenship, and for us to take really citizenship as a serious subject matter, that we will not be renouncing that if we want to and claiming claiming it otherwise. Let's go to suffrage. So the pronunciation of which is suffrage. No, it is not suffrage. It is suffrage. So it is a political franchise distinct from mere voting rights to vote gained through the democratic process. So that is suffrage. So what are the scope, or what is the scope of suffrage? In ordinary speaking kasi, if we are talking about suffrage, election na yan. But to tell you, that is a misnomer, no? Yan ay maling paniniwala. Because suffrage have several inclusions. No? Napakadaming included dito. So, election is only one of them. No? So, election is included in suffrage. In other words, a part of suffrage is election. No? So, election refers to the means by which the people choose their officials for a definite and fixed period, and to whom they entrust for time being the exercise of powers of government. Kaya di ba, last year we had our election. After 3 years again, we will be having another one. Initiative. It also includes initiative. So initiative refers to the power of the people to propose amendments to the Constitution or to propose and enact legislation through an election called for the purpose. Once that we will be discussing the legislative branch of the government, then we will be discussing this initiative, if how shall it be done. And also, how it will be approved, that is by means of referendum. In relation to the Constitution, that is known as plebiscite. So, like for example, before adopting the 1987 Constitution, we had a plebiscite. Okay? At papipiliin ang mga tao if they want the 1987 Constitution or not. And overwhelmingly, napakalaking percentage ang namili na kagustuhan nila ang 1987 Constitution, so it was duly enacted. If you will be asked, what is the Constitution of the Philippines that did not undergo a formal plebiscite? To tell you, that is the most recent is the 1973 Constitution. The 1973 Constitution did not undergo a formal plebiscite. So, to cut the story short, the scope of suffrage are the election, initiative, referendum, and plebiscite. So, what are the qualifications? What are the qualifications of a person to exercise suffrage, or yung tinatawag natin na right to vote? So, first is he must be a citizen of the Philippines. And next, not disqualified by law, at least 18 years of age, and resided in the Philippines for at least 1 year dito sa Pilipinas, and in the place wherein he is going to vote within 6 months. So, we will be discussing this one by one, the citizenship requirement and the residency requirement. So, let's go to the citizenship requirement. Okay, let's go to the citizenship requirement. Almost all, okay, halos lahat naman ng bansa, as a requirement for them to vote is it must be a citizen of that country. So that is now the problem with some dual citizen, with persons with dual citizenship. Because, for example, they are citizen of US, kung election sa US, they will be going there to have their election. Kung election naman dito sa Pilipinas, they are coming here to have their election. So, pwedeng yan ang isa sa criteria to determine dual allegiance, isn't it? Let's go to residency requirement, which is very important. Also very important. In relation to, and the case in relation to this is Romualdez versus Regional Trial Court. What happened in this case? Si Romualdez, kamag-anak ni Imelda Marcos ito. To tell you, the full name of Imelda Marcos, the former First Lady, is Imelda Romualdez Marcos. Kamag-anak niya to. No? So, nung pinatalsik yung Marcos dito sa Pilipinas, kasama na sila doon. Okay? Kasama na sila doon. They went to the United States. So, the complete name of this person is Philip Romualdez. Philip Romualdez, I repeat, is kamag-anak ni Imelda Marcos na naging right hand ni former President Marcos. So, inulit ko, nung pinaalis yung Marcos family dito sa Pilipinas, kasama na sila doon. He stayed, Philip Romualdez stayed at the United States for several years. So, pinatalsik sila noong 1986, tapos bumalik siya ng December of 1991. Okay, December of 1991. May of 1992, meron ng election. Okay, so inulit ko si Romualdez, umalis siya dito sa Pilipinas, pumunta siya sa US, nung patapos ang 1991, bumalik siya dito sa Pilipinas, nung May of 1992, nagkaroon ng election, so nag-file siya to become a voter. Okay? Gusto niyang, he wants to become a voter noong May 1992 election. So, may nag-question sa kanya. Sabi nila, Romualdez, Philip Romualdez, you cannot become a voter in May of 1992 election because consider this. So, ang qualification, ang last qualification ay dapat naka-reside ka dito sa Pilipinas within 1 year bago ang election and within in the locality where you are going to elect within 6 months bago election. Kaya ang sabi sa kanya, Romualdez, you are disqualified. You did not complete the 6 months residency in the locality and the 1 year residency dito sa Pilipinas. So, tama ba yun? Pwede ba siyang i-disqualify to vote? To tell you, according to the Supreme Court, in election cases, the court treats domicile and residence as synonymous terms. Parehas ang ibig sabihin ng residence at domicile. Domicile denotes a fixed permanent residence to which, when absent for business or pleasure or the like reasons, one intends to return. At ang tawag natin doon, animo revertendi. So, ang sabi ng Supreme Court, qualified si Romualdez na maging voter. Why? Because totoo na nasa US siya. In the whole duration of 1986 and up to 1991. But he has the intent to return. Kasi noong 1987, he is petitioning the government na bumalik dito sa Pilipinas. Pero yan lang, hindi siya pinayagang bumalik dito sa Pilipinas. So I repeat, he has the intent to return here in the Philippines. So, dapat may bilang daw yon. Okay? Yung pag-alis na dito sa Pilipinas is hindi na gagamitin laban sa kanya because he has the intent to return. Katulad ba yan ng the very simple explanation of that is if you are in the library, may upuan sa library, iniwan mo ang bag o gamit mo sa upuan na yun, nag-CR ka lang. So, is that seat still yours? Yes. Because you have the intent to return. Dahil iniwan mo ang gamit mo doon. Okay? That is a very simple illustration of this case. No? So, in other words, the physical and actual presence here in the Philippines is not, hindi yan ang hinahanap sa fourth requirement or qualification of exercise of suffrage. The important thing is you have the intent to return in that place. So, let's go to other qualifications in or other facts in relation to the right of suffrage. So, no literacy, property, or other substantial requirement shall be imposed on the exercise of suffrage. Ibig sabihin, literacy means hindi kailangan na you must know how to read and write. So as you observe during election, even those who do not know how to read and write are still allowed to join the election, to become voter. No property requirement. Ang ibig sabihin ng property requirement ay kailangan na may property ka in that place before you will be allowed to vote in that place. Okay? So, yan ang ibig sabihin ng literacy and property requirement. So, let's go to the disqualifications. What are the disqualifications of a person in relation to the exercise of suffrage? So, first, is if a person is sentenced by final judgment. We all know that under the subject criminal justice system, when can we consider that the judgment of conviction becomes final? Diba? We let you memorize that. Wherein, first is after the lapse of the 15-day period to appeal, the waiver of the right to appeal, the application for probation. So those are the instances when the judgment of conviction becomes final. And he will be suffering an imprisonment for not less than 1 year. So unless that disability has been removed by plenary pardon or granted amnesty. So as stated here, any person disqualified to vote under this paragraph dahil sa conviction ng krimen ay automatic maibabalik sa kanya after 5 years, okay, na napagsilbihan niya ang kanyang sentensya. So, those who have committed rebellion, sedition, so they are also disqualified to exercise the right of suffrage. And of course, those who are insane, yung mga baliw at incompetent, they are also disqualified to exercise their right of suffrage. What are the systems that must be established by the Congress in the right of the citizens to suffrage? So first is the system of securing the secrecy and sanctity of the ballot. So as you observe during the election, there are some hindrances that are placed in each table in order to ensure that sekreto yon, ano? Hindi alam ng iba kung ano ang binoto nyo during the election. And of course, the Congress must also establish a system of absentee voting by qualified Filipinos abroad. Bakit tinawag na absentee voting? Because they are not here in the Philippines, but they are working abroad, but they are citizens of the Philippines, so still they are qualified to vote. And the procedure for the disabled and illiterates to vote. Okay, so these are the things that must be established by Congress. So let's go to the case of MACALINTAL versus COMELEC. The case of MACALINTAL versus COMELEC, this happened because of Republic Act 9189. Yung tinatawag natin na the Overseas Absentee Voting Act of 2003. So under this law, all citizens of the Philippines abroad who are not otherwise disqualified by law, at least 18 years of age, may elect. So what are the qualifications? They are residing abroad. They are not disqualified by law. They are at least 18 years of age. And of course, they are citizens of the Philippines. They can elect, but limited only to the following positions. To the position of president, vice president, senators, and party list representatives. So they cannot vote for their mayor, congressman, governor, and others. Because I repeat, the absentee voting, the qualified voters abroad may vote only for the president, vice president, senators, and party list representatives only. So, because of this provision of the of Republic Act 9189, question na ito ni MACALINTAL. Sabi ni MACALINTAL, look at the provision of the Constitution. Ito ang qualifications to become to exercise suffrage. Okay? First is kailangan na nandito siya sa Pilipinas within 1 year at sa locality wherein he is going to elect within 6 months immediately preceding the day of election. Ang ginawa ng batas na yan, 9189, ay qualify niya ang mga Filipinos abroad na wala naman sila dito sa Pilipinas. So that law is unconstitutional. So, is that law and is Republic Act 9189 unconstitutional? To tell you no. Sabi ng Supreme Court, by the express provision ng ating saligang batas mismo natin ang nagsasabi na the Congress shall provide a system of absentee voting by qualified Filipinos abroad. Kaya, yung mga nasa abroad na Filipinos, pinapayagan sila mismo ng ating saligang batas na bumoto. Okay? So, I repeat, Republic Act 9189 is not unconstitutional. It is constitutional. Okay? Let's go to the three branches of the government. Just to give you an overview, okay, in relation to these branches of government. So we all know that we have the three great branches of the government. So we have the legislative, we have the executive, and we have the judiciary. The legislative branch of the government is charged with making laws, and subsequently, when the need arises, to alter or repeal them. In Tagalog, ito yung branch ng ating government na gumagawa ng batas. At kung kailangan, ay papalitan ang batas na yon. No? Our legislative branch is consisted of a bicameral Congress. Bicameral because there are two. Okay, there are two chambers. We have the upper house, which is the Senate, and we have the lower house, which is the House of Representatives. The Senate is headed by a Senate President, and the House of Representatives is headed by the House Speaker. The legislative branch of the government is known to have the power of the purse. Okay? It has the power of the purse or wallet. Why? Because sila ang may hawak sa pondo natin. No? So I repeat, the legislative branch, the lawmaking branch of the government possesses the power of the purse or the power of the wallet because hawak nilang ating pondo. The executive branch of the government is headed by the President of the Philippines. So we have President Duterte, who is the president that we have. So the executive branch is known to have the power of the sword because the sword is a representation of power, strength. The sword is a representation of strength. So the executive branch is possessing the power of the sword. The judicial branch is consisted of our courts. Okay, it is consisted of our courts, and it is headed by the Chief Justice. So you may ask, what are the other things that we must learn in this judicial branch, executive, and legislative? We will be discussing them later. What I only want to tell you at present is with respect to an overview about them. There are three great branches of the government, and they are separate from each other. Yan ang tinatawag natin na the doctrine of separation of powers, wherein the legislative, executive, and judiciary, they are separate from each other. But they are coordinate and co-equal. Ibig sabihin, sila ay magkahiwalay pero hindi nangangahulugan na sila ay talagang hiwalay na hindi na nagpapansinan. They are still coordinated with each other. And theoretically speaking, they are equal with each other. Walang mas mataas, walang mas bababa sa tatlong branches ng government na ito. So, you may ask, Sir, bakit sabi mo walang mas mababa, walang mas mataas sa tatlong branches ng government? Ang judiciary naman, palagi niyang sinasabi na mali ka, o mali ang judiciary, ay mali ang legislative, o mali ang executive. So isn't it in some of our court decisions, it was stressed that the judiciary is declaring that mali si executive, mali si legislative. Does that mean that there is judicial supremacy? Mas mataas ang judicial branch kasi imaginin mo siyang nagsasabi na mali si executive, mali si legislative. To tell you, no. There is no such thing as judicial supremacy. We will be discussing that later on if we will be going to the discussion of the judicial branch of the government. No? So, let's go to the case of Blas Ople versus Ruben Torres. What happened in this case? Si President Ramos noong 1996, nag-issue siya ng isang order that is known as Administrative Order number 308 na nagsasabi na kailangan magkaroon tayo ng computerized identification reference system. Yung tinatawag na national ID system na palaging ino-oppose ng mga rallyista. No? So, according to this Administrative Order number 308, lahat ng Pilipino dapat magkaroon ng ID. And that is known as, I repeat, the National Computerized Identification Reference System. In short, that is known as the National ID System. Pwede ba yun? Pwede bang sabihin ng President ng Pilipinas na lahat ng Pilipino dapat magkaroon ng National ID System? Ng National ID. So, to tell you, according to the Supreme Court, hindi pwede yun. Why? Because it affects all the Filipinos. Kung gusto ng government na magkaroon ng national ID ang lahat ng Pilipino, hindi ang President ang gagawa sa batas na yun. Dapat ang gagawa sa batas na yun ay ang legislative branch of the government. Inulit ko, hindi yung President. Kasi affected lahat ang mga Filipinos. So, in other words, if there is a law that wherein applicable sa lahat ng mga Filipinos, hindi dapat President ang gagawa sa batas na yun. Ang gagawa sa batas na yun ay yung legislative branch of the government. So, let's go to the case of Rejuel Incorporation versus Agregado. Ito naman, ang kasong to ay with respect sa judicial branch ng ating government. Ang ating judiciary kasi, specifically the Supreme Court, sabi ng ating Supreme Court, gusto naming mag-purchase ng gamit namin. Okay? So, I repeat, sabi ng Supreme Court, gusto naming mag-purchase ng gamit namin. O ito ang ipo-purchase namin. Radio lang naman. And it will be facilitating yung trabaho namin dito sa judiciary. O ano ang sabi ng executive? Huwag yung bilhin yan. Diba? Di natin alam kung anong rason. We don't know the reason. Perhaps baka sabi ng executive, huwag yung bilhin yan. Baka ang rason ay walang pondo. Pwede ba yun? Pwede ba yun nasasabihin ng judicial branch na kailangan namin yan, pwede namin i-purchase? Tapos sasabihin ng executive branch, hindi pwede, hindi nyo pwedeng bilhin yan. Can the executive do that? To tell you no. Why? Because there is a separation of powers and authority between them. Diba? Sabi ko, tatlo ang branches ng ating government. We have the judiciary, we have the executive, we have the legislative. So they are equal with each other. No one can control the other, no? Under the doctrine of separation of powers. In relation naman sa Maceda versus Vasquez, ito yung, ang kasong ito ay may isang judge by the name of Maceda. So, to facilitate the discussion, there was a case that was filed before the ombudsman. Tapos, sabi ng ombudsman, may nasampahan na kaso dito. At judge pa naman ng judge, RTC judge. So, ikaw judiciary, i-present mo o ibigay mo sa akin ang mga dokumento na kailangan ko. Kaya inulit ko ang ombudsman na hiwalay na office, hindi naman siya under ng judiciary. Sabi niya sa judicial branch ng ating government, ibigay niyo sa akin ang mga documents na to. Dahil nakasuhan ang inyong judge dito sa ombudsman. Pwede ba yon? Can the ombudsman dictate, pwede ba niyang diktahan ang judicial branch ng ating government at sasabihin na ibigay mo sa akin ang mga dokumento na ito at dapat i-provide niyo ang mga witnesses against a judge? To tell you, no. Ano? So, sabi nga dito sa PowerPoint presentation, the ombudsman may not require the Supreme Court to submit its record pertinent to the crimes allegedly committed by Judge Maceda. Kasi kung gagawin natin yon, kung papayagan natin na didiktahan ni ombudsman ang ating court, then the principle of separation of powers is violated. No? So, that's it. That is the end of part 2. Okay? So, ladies and gentlemen, that is the end of part 2. Listen, understand the presentation, and next meeting is we will be having a graded recitation. No? Thank you. Thank you.